Distinguished participants of the St. Petersburg Legal Forum, may I announce the opening of the panel discussion of the idea of law and justice in the European tradition. First of all, my gratitude to all of you for displaying such an interest to the topics which we will be focusing on today. This section is quite unusual because it is placed somewhat in a special manner among other sections of the forum, as opposed to many narrowly specialized legal sections and sessions which you see in the program and which you perhaps have already visited. It is quite broad and interdisciplinary, and it gathers the representatives of not just the legal community, but also scholars from various parts of humanities. And this is not by chance, because talking about the idea of law, sources of law in its understanding, cannot be limited to just one narrow area. As to why we decided to have this within this forum, is translation okay? Can you hear the interpretation?
Five is English.
So perhaps I will not make a mistake if I say that a sad reality of today is a lack of trust to law per se. And the point is not just having the legal knowledge, because many people are deeply convinced that law and justice is one thing, and law as a piece of legislation is somewhat different, and it is disconnected with ethical categories. So there is a crisis of sense, and there is a feeling that in the minds of the people, the law is attributed to a kind of set of tools. Unfortunately, this is true for some legal professionals. Legal professionalism per se is very often looked at outside the scope of ethics. Those of you who visited yesterday the opening ceremony would remember that the topic of governance of law and the need of having ethical criteria have been mentioned in many presentations, including that of the head of the government. And perhaps you would remember that the dean of the Legal College of Oxford mentioned that now we have such a situation when in terms of professional level of attorneys can be judged as to how eloquent they are and how well they can make a court to adopt an unfair decision to the benefit of the criminal. Looking at Russia, where many institutes in the recent couple of decades have been resurrected and brought back to life, and we're celebrating the anniversary of the new Russian constitution, well, all that is even more evident in the Russian tradition. When we talk about the law, and at the same time we see the disconnect with ethical and the notion of law and justice, all that makes the system somewhat artificial and does not increase the legal awareness and legal culture. So we think it is very important to have, along with a very narrowly specialized topic, as the focus of our discussion, the general notion of law and justice, which is very important for the international legal community. This is the first attempt to this effect, and I believe that it may provoke a serious discussion in our community. A few suggestions regarding our agenda. This round table is not perfectly round, as you can see looking at the arrangement of the room. But still, we do hope that the participation will be reciprocal between the panelists and the audience. I believe all of us have our own understanding of the topic and the key positions. So what I would like to have our panelists do is just try to broadly draw the areas for discussion. We are limited in terms of time because at 1800 hours the tour to Hermitage will begin. So I would like to ask our speakers, keynote addressers, to have that in mind, and perhaps we'll ask them to speak for 10 minutes. Perhaps if 10 doesn't work, then a dozen of minutes, but better to be within 10. And let us also agree that after the end of every presentation there can be one short question to clarify the points mentioned, and more discussion will be held after all the presentations are done. After all the keynote addressers will speak, we'll have a small coffee break, and then after the coffee break there is room for a discussion Q&A. We already have a number of people who expressed the wish to speak within the discussion time. If there is anyone else who wants to do so, please write your name and your organization on a piece of paper and have it passed to me. If you do not mind, then let us start along with the agenda. We're expecting the minister a little bit later to join us, and most likely he will generalize on the ideas at the end of our roundtable format discussions as to all of the ideas which are being voiced in the forum. So let's start with the speakers which we have here with us now. And first and foremost, I would like to give the floor to Professor Werner Kravitz from the Münster University, a well-known scholar in the theory of law. Professor, the floor is yours.
Could not follow you because from technical problems.
I'm just saying that I'm giving the floor to you.
Am I asked to start or?
Yes.
Fine.
You're most welcome.
Well, I would like to speak about law and justice in legal communication. And I will stick to modern legal communication. And when I say modern, I don't mean agile communication or early modern communication or postmodern, just modern. So I have to say some words what I understand when I say modern. And my question is how we can conceptualize legal thinking about these topics. My approach to the notion of law and justice, especially in European tradition, is from the point of view of general theory of state and law. In what follows, I distinguish between first, justice according to law, second, justice against law, and third, justice beyond law, ethics, morals, and things like that. My focus is on the first position, justice according to law. Today, when one examines the existing legal systems of Central Europe, especially those of Western and Eastern Europe, one gains the impression that the state or the states no longer occupy the position we have hitherto ascribed to them in the theory of state and law. I would like to present 3 points for discussion. Point 1 is globalization, westernization, and multiple modernities. The classical legal theorists like Marx, Durkheim, and in particular Max Weber have analyzed modernity and modernization by the cultural and institutional factors and constellations which came together historically in Europe. They assumed more or less that this cultural program would be adopted globally in the process of westernization. The classical authors all assumed that the cultural program of modernity, as it developed in modern Europe, and the basic institutional constellations that emerged there, would ultimately take over all modernizing and modern societies. With the expansion of modernity, they would prevail throughout the world. Something of a hegemonial approach to law and society. In what follows, I want to distinguish between modernization and westernization. Taking into account the sum of all legal communications in our global legal world, it might be that in the development of law and justice today, all societies in sum are growing more modern, but less Western, whatever that may be. Following the lines of Shmuel Eisenstadt's ways of theorizing and worldwide legal thinking, we have to do it today with quite a new paradigm of social, cultural, and legal evolution named multiple modernities. The notion of multiple modernities denotes a certain view of the contemporary world that goes against the views of the classical theories of modernization and of the convergence of industrial societies long prevalent in the 1950s. Theoretically, and this is my main thesis, multiple modernities is not a type of legal theory that enumerates historical events. It is a multidimensional theoretical description of structural evolution, especially of evolution of law and legal systems. What we need today is a multi-level approach to law. Multiple modernities do not assume that global modernity is derived from the West as a single pattern. Multiple modernities is to be understood as a critique of the classical theory of modernization. We have evidence that modernization does not lead to a unification or a convergence of social structures and legal systems. Therefore, modernization is neither a way towards evolutionary universals, for example, human rights or Rechtsstaat, nor is it based on them. Multiple modernities is a structural change that continuously modifies our belief systems and our legal systems and their implementation in a process of transformation and social interaction. Today, when one looks at the existing legal systems in Central Europe, and also at those of Western and Eastern Europe and beyond, there are many modernities, not one single pattern of modernization. And there are also many modernities of legal systems, not only one single world law, as Harold Berman has pointed out so convincingly. In what follows, I distinguish between first, state legal systems and second, non-state legal systems. And I distinguish further between formal and informal law. The concept of law based solely on the state and concerned exclusively with the formal state law seems too narrow. The concept of law has to take into account the manifold informal social conditions and societal prerequisites for the production of law. Point 2. From the point of view of a general theory of law and of systems theory, law comes into existence in all institutions and social systems, namely, 1, in interaction systems, 2nd, in organizations, and 3rd, in the variety pool of society. The latter can be a regional society, let's say like Russia or Western societies taken together, or on a higher level of abstraction, global society as a whole, encompassing all legal communications in the world in our globalized legal world of today. I would like to distinguish here between first regional societies and world society, or better, global society as a whole. The last point is rather important for my approach to law and general theory of law. What I mean by global society is not, as in Luhmann's approach, world society in its differentiation into independent functional subsystems of society: political system, cultural, economics, and law. Global society and law, seen from my point of view, is but the social reality of law and legal order in interaction and organization systems, as well as in state legal systems. My system's theoretical approach to law differs from Luhmann's, apart from the fact that he does not mention state legal systems. The concept of law and global society used by me here rests on the differentiation between regional and global society. That is, society as a whole, encompassing all legal communications in our global legal world. At present, however, we have neither one global law nor one global state, and there are also a number of reasons why it is highly unlikely that either of them can or will ever exist. Point 3. An information and communication theory dealing with the relationship between norms and action in legal communication is not a finished product. To construct and develop it is a highly demanding task which remains as yet unaccomplished. In pursuing this purpose, a very broad concept of communication in the context of the modern institutions and systems theory has to be used as a basis. Law and legal system, seen here as a normatively structured communication system comprising all organizations and interactions in the world, on the level of global society, is no more than a system of regional societal systems, which includes and integrates all the different national legal systems. National legal systems are embedded in these broader global society. The technological, economical, political, cultural, and legal globalization do not play together to one and only one global society. This is my main thesis. The concept of legal communication comprises with it, therefore, the entirety of directives and norms which are self-referentially produced in the legal system of modern society. Self-referentially means with continual social and logical reference of the respective legal system to itself. We have to start from our ideas of legal system, and only then we can grasp the world around us. The concept of legal communication extends to all forms of legal action and all kinds of normative attributions of responsibility, in particular to the attribution and imputation of rights and duties, as we know them today in the realms of civil law, criminal law, and public law. You see, this is a very broad concept from the point of view of general theory of law and state. In reducing complexity, the legal system limits itself to certain kinds of communication. That is, only certain kinds of communication generate further communication. and thereby continue the operation of the system. One communication leads to another, which leads to another, which leads to another, and so on. There is no starting point or no final point unless the system disintegrates. Somewhat like a digital computer, the legal system does this by selecting communications according to a binary code. The code is what gives communication within the legal system its legal meaning. And this excludes other meanings from the system. So you cannot link moral orientations to the legal system because it's self-referential. That could be only done by the parliament and other instances. The code, especially the legal code, could be translated as law, non-law, legally valid, legally invalid, legal, illegal, right, wrong, just or unjust. There is no room in this legal system in global society to add other meanings. One must use channels of transforming. I think we will speak about that. Obviously, in today's society, many different communications can have legal, political, economic, religions, and other meanings. The chairman just told us what's going on in reality. Because of the binary coding system, however, each communication will have only one meaning within each system. The legal system processes legal communications internally. Which communications belong to which circuit is a question determined by each circuit itself according to its own code. I hope that you can understand better now what I mean when I say that contemporary general theory of law is a theory of self-referentially operating social legal systems. I know that this is a very abstract definition. I hope they will have a chance to explain it a bit in our discussion. To sum up, modernity is not an evolutionary one way to a global civilization and a universal legal culture. We live in a time of multiple modernities and multiple legal systems in their respective social environments. This is leading us to a new paradigm of theorizing about law. We have different normative levels at which justice may be prescribed. This includes the religious, moral, political, economical, cultural, and legal levels to which we may refer. But in general theory of law, this leads to the breakdown of justice beyond law and to the turn to a communicative legal system in their respective environments. Unless I'm wholly mistaken, the turn of the social reality of law is now not only possible, but indispensable. This is why, with a view to the requirements to be met by a theory of normative legal communication, an attempt is here being made to sketch the outlines of a socially adequate framework of legal communication. By the way, this approach rejects, as a matter of principle, the limitations imposed on legal thinking by natural law and its successor, the law of reason. Law is far too important a matter to be left to moral philosophers who draw on natural law and law of reason. Thank you.
Уважаемый профессор Кравец, благодарю вас за...
Mr. Kravitz, I would like to thank you for your intervention. I'm very happy that you have joined our discussion, and you quite correctly call into question this
definitions. Mr. Sladkov have a question, I believe. Colleague, in the beginning of your intervention, you said that there is justice beyond the law. Can you say, can we talk about the law beyond the justice?
Yes, of course, we can. Because you have begun to do that, and I will join you. What we need is a new orientation about positivity of law. I would like to speak not of positive law, because then you have the meanings natural law, positive law, and all these schools of natural law, law of reason, and so on. The problem is that scissors in our legal thinking, and I start from positivity of law as seen from the angles of social sciences. We cannot stick only to hermeneutics in legal law. Of course, as jurists, and if we have to do legal doctrine, we start from constitution and statutes, but we have to do everywhere with context problems. And our problem is, how can we grasp this context? And my approach is to work out a framework on the conceptual scale, which is open to not only to texts and context problems in a hermeneutical way, but which is open to the social sciences. And then we must organize the discussions with other sciences, and therefore we need a new general theory of law and state.
Большое спасибо, профессор
Коллега,
Кравец.
но ведь хочется получить простой ответ. Можно или нельзя?
Can we or not? This is the question.
I did not grasp the translation. General.
Can we or not? That was a question.
Мы не успеем завершить в принципе.
Let's keep the discussion maybe at a later. Just move it.
Just to put it short, we can, if we, I try to do it on the basis of legal thinking, which is organized, as I have formulated, as a multi-level approach to law. We can make a difference between the different levels: legal praxis, dogmatics, methodology of law, a general of law and state in the old sense, but then come to cooperation between different sciences. And then we have the problem how to integrate these levels. And we need new concepts to come on good terms in our discussions.
Большое спасибо, профессор Кравец. Еще раз призываю всех свято соблюдать.
Thank you very much, Professor Kravitz. I would like to ask all of you to stick to the procedures. And now I would like to give the floor to our Belgian colleague, the professor of the University of Ghent, Mr. Mark van Hoek. You have the floor, sir.
Well, first of all, I want to tell you that the Russian translation of the full text of my speech already appeared in the world-famous Pravovedenie, in the issue which appeared today, I guess. So for those interested in it, I refer to that journal. Where should I orient? Yeah, okay, it worked. Yeah. Yeah. Okay, so basically I will limit myself to the text of the PowerPoint presentation. So the starting point, and that is also partly what Professor Kravets said, the history of 20th century has shown many changes, and among other things, they have challenged our conceptions of democracy. We have created the conception of democracy in the 19th century, which was emphasizing the majority rule. The majority of a parliament decides. That has been challenged by two issues. That's the protection of minorities, of minority groups, and the protection of fundamental rights of individual citizens. Moreover, the multi-layered legal structure of Europe, and I mean both European Union and the Europe of human rights, but it is most visible within European Union. This legal structure, together with an increasing role for courts at the expense of parliaments, has turned upside down the traditional model of the monopolistic, centralized nation-state, which, at least in continental Europe, used to give absolute priority to the legislator. Now the question is then, how do we define the limits of democracy, and how do we define the scope of human rights? As it is obvious that human rights have been broadened in the jurisprudence of the European Court of Human Rights, to such an extent sometimes that they have been talking about the banalization of human rights, as everything becomes a human right, like, for instance, having on time a break during this session and coffee, which I think is a human right, but it's also an example of banalizing the basic idea of human rights. Now, what we see is that there is a constant communication process among national and European legislators, among national and European courts, among constitutional courts. More or less half of the European countries have a constitutional court, and there are regular meetings of judges in these courts, and they read each other's case law. And these decisions, together with doctrinal and political debates, contribute in turn to the making of a general opinion in society. As on one hand, they represent opinions in society, but on the other hand, they are changing these opinions. They are creating new opinions and also creating a common European constitutional culture. As if we think the same, we share a common culture on these points. The question is, how do we legitimate such court decisions? Well, I think that the acceptance of decisions of constitutional courts, and I would say also the European Human Rights Court in Strasbourg, is a constitutional court. The acceptance of these decisions by the relevant interpretive community constitutes the basis for its legitimation. Only the first two are. Yeah, well, at least we had two slides. Okay, then I will go on without the other slides, which don't seem to be available. Well, traditional theory in continental Europe emphasized direct elections for democratic legislation. And from that point of view, the opinion was that courts should not create law. Courts should just apply the existing law. But today, human rights theories precisely see the courts as protectors of individuals against political majorities. which means that both constitutional courts and the Strasbourg court have become a kind of natural law court, if I may say so, overruling legislators. The question now is, how can we legitimate such court decisions? And there have been quite some discussions about it, with arguments such as constitutional judges not being directly elected by the citizen. The answer is, but at least they are appointed by a directly elected body, which is usually Parliament itself. The second point is that the power of constitutional judges is much more limited than the power of legislators. The judges do not as such create rules, they abolish a statute. It's different for the European Court in Strasbourg, but constitutional courts generally act like this. And also examples in the United States show that direct election doesn't offer the best guarantees for the best judges being elected. Constitutional courts and parliaments have today a different task. And that means that they have a bit lost the hierarchical relationship which courts and legislators used to have before. When we look at the way the European Union works, there is increasingly a division of labor and a circular relationship, not a hierarchical relationship, among the different levels. And I mean not only European Union and the member states, but also increasingly the regions within those member states, which often have their own parliaments and their own competences. And also a division of labor and circular relationship between courts and legislators. We also have a bit lost the idea that law is made once and then can be valid for a long period, if not forever. We are aware of the fact that law is constantly being made, adapted, and developed in legal practice. It is not made at some point of time and afterwards simply applied. It is constantly made, adapted, and developed in legal practice, which means most prominently by judges. And also the legitimation of this practice is constantly achieved through a deliberative communication. What does it mean? Well, if we take the normal procedures in court, then you can see that there is a kind of communication process between the parties and the judge. When there is appeal, the higher court will not only take into account the arguments and evidence offered by the parties, but also the earlier decision by the lower court. When a decision of a court is published, legal scholars will give their comments, criticize or support the decision, put it in a broader context from which its value or its weakness appears. And those comments may in turn influence future decisions of the same courts or other courts. Sometimes court decisions are discussed in the media, which means a shift from professional legal community to the public forum. And especially decisions of constitutional courts may be discussed in society at large when they involve fundamental ethical or political issues, as then the whole public sphere may be involved. And democratic legitimation of these constitutional decisions is offered by those deliberative processes. It is the public forum function through which public control, criticism, and debate becomes possible, and also the acceptance of a decision in society. So it means that authoritative rulings by parliaments or by national supreme courts have been replaced by a broad European interpretive community, which is determining the scope of democracy and the fundamental rights of the citizen through a constant dialogue. And I want to give just one example at the end. That's the example of two decisions of the European Court of Human Rights on the presence of crucifixes in Italian public buildings. So some people who were not Catholic said that they were offended by this crucifix being hanged in public buildings. And in 2009, the Strasbourg court has decided that indeed this infringes the freedom of religion. Those who are not religious should not be forced to see this as a symbol of public authorities. Now, the result was that the Italian government should take away all these crucifixes in the public buildings. But in Italy, this was considered a shocking decision. And the Italian government not only said that they never would remove the crucifixes, but according to the current procedural rules, they could ask the relegation to the Grand Chamber of the court, which they did. And then something, in a way, strange happened, as the first decision was taken with a very large majority. And the second decision decided the opposite, unanimously. So it was quite strange to find within the same court one chamber deciding with a very large majority crucifixes are infringing the freedom of religion, and the Grand Chamber unanimously deciding it did not. And why was this? Because the Strasbourg court was sensitive to the criticism that it acted too much as a legislator at the expense of national parliaments. And the Grand Chamber considered that there is no unanimity on the matter throughout Europe, so that it is up to the states to decide within their margin of appreciation whether crucifixes can, or even should, be hanged in public buildings. That was a kind of communicative legitimation, and I think it was wise of the court to decide like this, as otherwise it would have weakened the authority of the court if they would have forced countries to do something which is not accepted in that country. Thank you.
Большое спасибо, профессор Ван Хук.
Thank you very much.
Thank you very much, Professor. I think your presentation gives some more food for our further discussion. Any questions to follow up? But the questions which would entail a short answer, not a short one. Okay, let's postpone it for the discussion bit. Perhaps if you do, we might run out of time. All right, go ahead. I'm from the Moscow University. My name is Orlov. Thank you very much, Professor, for your presentation. I was especially pleased to see two statements in your presentations, which I would like you to follow up on. First of all, in the very beginning of your speech, you said that the European tradition of human rights, which we have now in modern times, makes a special emphasis on the rights of minorities, because it is exactly the rights of minorities that demand special attention and should be therefore protected in a proper way. At the same time, we have to take into account that the European society at large over the decades has seen certain changes from the point of view of its ethnic and religious composition. If previously minorities meant the basis of some, social criteria, or minorities in terms of sexual preferences, now, as perhaps I see, special emphasis is attributed to ethnic and religious minorities, the people living in the European states, and first and foremost those which are Muslims, who are Muslims. Could perhaps this statement lead to a certain crisis of the doctrine of protection of the rights of minorities in Europe from this point of view? Can there be some kind of clash, because the minorities now living in Europe have a certainly different cultural paradigms and their views and their attitudes, and sometimes those are contradictory to the traditional ones for the European society. Indeed, this is a very interesting and relevant question, but I'm afraid that if we engaged into discussion and the answer to the question, we will run out of time. Perhaps Professor Van Hook could say just a couple of words now, and then within the discussion bit to have a fuller answer.
Okay, I will just give another example to show that the problem is intricate. The United States had at the end of 18th century, the Declaration of Human Rights saying all men are born equal. Still, they kept slavery another 70 years. Why is that? And that was clearly against the declaration, because they didn't consider the black people to be human beings. And that is just the same, like it's a matter of words, of defining. When you see how torture is generally prohibited as one of the consequences of human rights, but with Guantanamo, the Americans called it thorough methods of interrogation instead of torture. And that is what is going on. So you define it differently, and then you say it's not a minority. If I say, well, university professors are a minority, we need to be protected, they will say, yes, but you're not a minority, which in a way is correct, and in a way it's true. Yeah?
Спасибо большое. Значит, можем продолжить, наверное, все-таки позже.
Thank you so much, and let's continue this discussion later on. Now I would like to give the floor to the head scholar of the Russian Academy of Humanities, Valentina Lopaeva. Thank you so much. Distinguished colleagues, the discussion of the problem of justice here, I think it's only the beginning, manifests the growing interest towards this topic from the part of the international community. In the basis of that, there is the feeling and the sense that addressing global issues, at least those which are coming to the crisis state, cannot be unfair or unjust if such problems, starting from the environmental crisis and up to the all the other ones, up to terrorism, can be successfully addressed, this can only be achieved through justice. That is coordination of all the positions of stakeholders. If we just operate with tools, we will not achieve the relevant effect, because the key reason of those global problems is the limitation of important resources for the humanity, which are vital, and this lack or deficit of resources makes the issue of a fair distribution a very relevant one, because it is a social virtue. It has a bearing for the justice of the distribution of social goods, and the vitality of such resources leaves no chances for having an apparently unjust schemes of distribution, because those who do not have fair distribution will fight to the end, even if though the end might be the total one. At the same time, those burning vital issues provides for the chance for their fair resolution. Well, there is a saying that we couldn't be happier if the unhappiness helped us. Sometimes social groups and separate people do not have the privilege for the safety which was previously inherent to the top-ranking parts of society. And to a large degree, because of the political and legal globalization lagging behind the economic processes, the risks and threats of globalization are marching hand in hand in terms of relevance for everyone. And this equality of strong and weak in the face of general threats, as Ulrich Perl emphasized in his publication, provides for the chance for the fair resolution, because fairness or justice is always the product of some agreement. An agreement can only be made between the equals, even though the equality can be in the face of the vital threat. Shaping up of the just order globally, which is based on the agreement, is opposed by various projects of forced resolution of the problem, such as unipolar world and shaping up some global government and bearing the sovereignties and dilution of international order through some kind of network-based normative systems, etc. In the foundation of all such projects, there is the concept of force, which is used to instill order. And this works at the level of certain sovereignties, because the challenges which they see now are to a great degree the echoes of global risks and threats, which make the problem of justice even more important. And even there, where the most relevant are particular national problems and issues, they have such a character which makes the problem of justice even more acute. And our Russian problems here are very exemplary. To a large degree, they're special from the point of view that dismantling of socialism through the privatization of socialistic properties was done through the most unfair model. And this is even worse than the Machiavelli type of privatization. This nature of privatization we had here gave birth to skews such as the confluence of power and property and illegitimacy of property and assets, which entails an entire set of ethic, social and other problems which just cry for justice. And yet, until recently, the problem of justice was primarily used by the lefts, and they were focusing on so-called social justice, which can only be regarded as a certain kind of redistribution of goods in the favor of the poor. And Immanuel Kant spoke about that once, saying that it has no underlying principle, that is to say that it is irrelevant for the search of the principles of fair society organization. And it is exactly within this context that the West has been working on the theory of justice. If we try to put in a nutshell explaining why we were not looking at justice in Russia for such a long time, we need to say that our society went into the age of radical changes. This was done having as our inherent quality the inability to make fair agreements. And that relates to all the principles which are attributes of fair or just order and society. And yet recently, in just a couple of years, the problem of justice has surfaced in many fora in this country, and this is a new qualitative parameter of this modernity. Every time we speak about justice, we see that there are two mental traditions. So the European legal culture, that is the tradition of the antique society, which is based on the understanding of the inner unity, which is basically equity, and the Christian or Bible tradition, which puts an equal sign between justice and mercy, mercifulness. And that is all inherent for the nature of the person. And as Erich Fromm put it, there are two principles of organization of our society. The matriarchal one, which is based on the unconditional motherly love, and patriarchal, which is based on the concept of fatherly love as the reward for achievements. And the synthesis should be such whereby the female and the male parts will not be antagonistic, but will be synergetic. And the key issues which arises from that is the one, what is the basis for finding that fusion, either in the unlimited space of moral perfection, or rather based on the area of law, which has evident borders. And the answer to this question will give us an idea as to what will be the focus of society. Either it will bet on the moral perfection and enhancement, or rather shaping up a just legal system and the immanent to it political system. The Russian legal philosophy, as you might know, was more in favor of the first approach, that is the understanding of the law and justice based on the concepts of moral issues and religion. And behind that there is the question as to what is public morale, and the feelings of the believers is being defined by the state. And this goes awry with the key notions of philosophy, because it is more about criteria between the law and the legal outrage. And it is not by chance that this approach was favored by the Russian philosophy of law, and it goes awry with the vector of development of modern rationalism in the understanding of law, which still continues. The essence of that rationalism is that the notion in accordance with which the law should be equal to, or should be coherent with justice as moral criteria, the theory of law from this sense goes to the sources which we find in the antique tradition, which say that justice is inherent to the nature of law. Moreover, there are multiple concepts of the understanding of law which are based on the post-classical rationality. The Russian philosophy of law in our today's tradition is focusing more on the rationalism of the understanding of the law, and it has been developed by academician Nersessians, who gives a more precise definition to the existential characteristics of the law. And from this point of view, the law is always just, and there is no justice beyond the law. And justice has as its component the definition of the law, and the law is the formal justice, which is an equal measure to freedom. Within that theory, the understanding of justice incorporates the idea of mercifulness, which is within the concept of the logic of formal equality. And the redistributional function in the social polities of the state is in line with social justice if it doesn't go beyond the border of legal offsetting, which makes the level of law capability more even among society, and this is decided and taken care of within the democratic process of lawmaking. Within the same logic, modern developments of international law are taking place, focusing at the principle of constitutional inequality, differentiated responsibility in international agreements on environment protection, and this is where we see the manifestation of the rationalization trend in the understanding of the law, which I mentioned, and it has both emotional and irrational capacities of the mentality, and this is the manifestation of flexibility and depth of the human mind and reason, and it leaves a good chance for the fair resolution of global problems which we face now. Thank you so much, Valentina Viktorovna. Just one question to clarify. Microphone is not on. Microphone is not on. We cannot hear questions without microphone. From the point of view of approach, which I favor, the law is. So let me repeat, am I right in my understanding that the law is a piece of law, pieces of law, and law in a more general sense are one and the same from your point of view? No. The point is to bring the two together and to come up with the law which is coherent with the essential notion of equality. We can only have the law doing something within the formal law, and this formal law has to be just. A very short question. Microphones, microphones, please. Microphones. Well, everything starts that with definitions. So, what is law? Well, law is the legislation or legislature or the body of legislation which conform to the principle of justice. One at a time, please. One at a time. Thank you very much, Valentina Viktorovna. Apparently, you touched upon very relevant and interesting issues. Now I would like to give the floor to Professor of the Lucerne University, Switzerland, Mr. Andrian Loretan.
Thank you very much. The constitutional state sets up criteria in dealing with power. Minister of Justice Alexander Konovalov, dear colleagues, ladies and gentlemen. I recently heard the performance of the 7th Symphony of Dmitri Shostakovich in our music hall in Lucerne. When the invitation of St. Petersburg arrived, I thought instantly of this experience, because I think he is one of the first or one of the cultural fighters against a totalitarian state. We in the West shouldn't forget that we have a different totalitarian state in the 20th century. Germany, Italy, Spain, Portugal, Hitler, Mussolini, Franco, Salazar. In this context, I would like to ask you, I would like to ask you, why does the law apply? The question of the original cause of law is a pivotal for any body, a Ministry of Justice, and a civil service. As a father or as a mother, you know, you can't tell your boy or your girl, the order is to obey because I've said it, that's it, point. In the same sense, positive law is there to be obeyed absolutely. This is the most dangerous form of legal positivism, which the great legal philosopher Immanuel Kant, in present-day Kaliningrad in Russia, already opposed in his writings in the 18th century. For the power of the law is sufficient into itself. Totalitarianism. In totalitarian system, the claim to power is total. That is, not only extends to public areas of life, but also pervades the private spheres. A totalitarian state wants to create a new human being. The law in this state becomes the instrument by which the human being is enslaved in the service of that particular totalitarian ideology. The bond between the exertion of state power and the principle of the rule of law is rejected. Even the oldest modern democracy we have, the USA, is conscious of incursions of power into constitutional legality. As we heard before, the US knows some secret prison in Europe, and it was the Swiss Dick Marty who functioned as a special prosecutor for the Council of Europe in this CIA affair. But in philosophy, we have, even in the old philosophy of Roman time, we have a philosopher called Aurelius Augustinus, which is also a church father. He determined the states that states without justice are nothing else than great bands of robbers. Great states without justice are nothing else than great bands of robbers, said Augustine. He quotes the following. No, I'm too early. Alexander the Great once picked up a sea pirate. The emperor asked, "How did you dare to make the sea unsafe?" The pirate retorted, How do you make the whole earth unsafe? I do it with a small vessel, and I am called a pirate. You do it with a great fleet, and you are called an emperor. What's the difference between me and you? Augustine summarized up, a state without justice is nothing else than a great band of robbers. That's why in every state today we don't have a ministry of law, we have a ministry of justice, which is different. That's why we have to think about what's justice. Legal positivism. The law is determined completely by the politics of power. To illustrate this thesis, the German jurist Hans Kelsen took the parable of Pontius Pilate in 1920. This reference to St. John's Gospel preoccupied Kelsen all his life. He used it in order to pinpoint the basic dilemma between power and right. The Roman governor doesn't know what is right. That's why he is conducting a vote. In this way, Jesus, like Socrates, the great philosopher already before him, was condemned to death unjustly through a majority decision. A democracy badly needs the rule of law. The constitutional state establishes criteria. In order to prevent injustice from being legitimized by the law, the constitutional state sets up criteria in dealing with power. First, the criterion of freedom. Immanuel Kant construes the concept of law as the practical relationship between one person and another. The general demarcation of the spheres of freedom stands for the four. The authority of the state to act is the prerequisite for the legitimate freedom of individual. I give you an example. If some boys play football together, they need an arbitrator or a referee that looks for the fair play, that looks that the players play following the rules. So we have the same situation with the state. I come to the second criterion of democracy. Within political philosophy, we have two sources of legitimation of constitutional democracy. First, liberalism and republicanism. Which liberties should take precedence? Are laws legitimate only if they accord with basic liberties, or, that's the liberal position, or are laws legitimate only if they emanate from a democratic decision-making process, that's the Republican tradition, or do we regard both principles as being equal in origin? Because democracy must not be confused with the arbitrariness of the majority, which we heard already. The criterion of fairness. When we speak about justice and injustice, it depends from which point? From the viewpoint of the perpetrator or from that of the victim? In the case we speak about justice appears not as an absence of virtue, as the philosopher Aristotle thought about, but as a refusal of acceptance, probably following Hegel. Human rights, in their individual and social specificity, are especially important indicators for such abuse of power. But as we heard yet, injustice, and with it the abuse of power, is a category embossed by history. For example, black people or women at a certain period accepted their lack of rights as a fatality that could not be avoided. Today, we say racism and sexism are two basic forms of abuse of power. In both cases, structural social injustice is derived from a group membership. This absolutely is incompatible with the concept of dignity equal to all men. I come to the next one, justice as fairness. To live under the condition of equality, and this is the situation of persons in a constitutional state, means two basic principles of justice following John Rawls. First, each individual has the same right to the comprehensive overall system of the same fundamental freedom. And the second, all public positions are open to everyone. Each divergence from equality must be justified. Rawls holds such a divergence in the field of freedom cannot be justified. The similarity between the justice theory and some biblical incentives of the justice tradition was pinpointed by the former president of the German evangelical churches, Bishop Wolfgang Huber. By way of conclusions, I would like to reduce Immanuel Kant's and John Rawls' generalization principles to the words of the Golden Rule, indeed present in various religions. I quote them according to the Gospel of Matthew. So, always treat others as you would like them to treat you. This sentence even an atheist can follow, because everyone wants to be treated as he should treat others. In this way, the fundamentals of generalization principles of Kant and human rights are both given. With this legal philosophical reflection, I have tried to recall the importance of criteria in accordance with the rule of law in dealing with power. I thank you for your kind attention.
Благодарю вас, профессор Ларитан.
Thank you very much, Professor, for the inputs, which was composed of very important Christian motive in terms of understanding of justice and law and the position of Rawls. Perhaps a separate topic for discussion can be that of human rights, because we can limit that to the positivistic understanding of that, but we can discuss it later on. If there are no short questions, I would like to give the floor to the president of the Urals Legal Academy, Viktor Perevalov. Viktor Perevalov, the floor is yours. Thank you. Distinguished colleagues, I side with my colleagues in terms of alarming situation in the area of ideas of law and justice, and I would agree with many a proposal which previous speakers and I feel the audience too are putting forward in terms of addressing such issues. What I would like to perhaps propose is a method which is in many ways similar with many theories which we mentioned. This is the human dimension of ideas of law and justice. I will just give you that in a number of theses to save our time. First of all, justice is something which is inherent to a human being. It is a quality, it is a part of a human existence per se. Law, in its, at a first glance, is what emerges through the development of a human being on the basis of reason and observance of measures of justice, and which was achieved in the interactions with other human beings. That is to begin with. And just recently I've read that scholars, American scholars from the state of Georgia, found out that monkeys or primates also have the feeling of justice, which is very close to that of human beings. This is not to say that we are stemming from monkeys, that monkeys are predecessors. No, no. This is just to underline that every human being apparently has that inherent feeling of justice. Another point is when we speak as representatives of the legal profession, trying to find out how all that is reflected in the objective and subjective law, and that entails a myriad of issues which can be discussed endlessly. And yet, I would rather believe that for subjective perception, for a specific human being, law in at certain levels is first of all perceived. First of all, this is positive law, the norms and the measures of punishment. This is very straightforward, and all the enforcement power which it is backed up with. And secondly, this law is regarded as something natural, as something inherent. A human being understands that he exists as the person who can use those rights. Human rights and human liberties are not limited to something which we can put within borders. No, there is a multifaceted multitude of concepts, and this is a topic in itself which is being researched into in the literature and in scholars.
Besides, individual is still thinking, a way of thinking, his perception modes maybe on the basis of those positive norms which he considers beneficial for himself, and he tangibly realizes some steps or acts, which means the tangible right for him currently. This is a positive behavior, way of behavior. Is ensured anomalies are regarded as exclusion, but there were times when anomalies were considered as a normal way of behavior, but in the course of the development of human society and development of the human categories, which is getting more and more natural, and which is demonstrated by the Constitution of the Russian Federation of 1993, which is faces the rights of a human being, and the European constitutions. But it's not enough, I guess. We'll look through the prism to the further steps which should be made in respect of the correlation of law and right and law, and maybe it's the right time to start from the basic, from those legal knowledge, which I believe is a sort of a set of knowledge, and if it's not taken into account, it would be just a waste of time. I'm fully convinced from the position of apes. I believe that there is genetically embedded knowledge which is genetically transmitted from one human being to another human being. Then the collateral, doctrinal and tangible knowledges, so I mean those legal knowledge which are present in the legal construction, legal laws, legal framework, and once it's not taken into account, we are risking it having some consequences which would be quite difficult to rectify, taking into account the time limits and the position of our moderator. I would like to stop here. Thank you. Thank you very much, Viktor Dmitrievich. I just have a feeling that we have already laid the groundwork for quite a serious discussion after the coffee break. Maybe I would suggest that we break for 15 minutes. Is it okay? The only difficulty is that you need to go to another wing of this building in order to get your coffee. So we will meet here in 15 minutes. Just a minor correction. So maybe 10 minutes. Still, I would like to fulfill my promises to... Sorry for being late, because some reasons I just missed some presentations, and I no doubt that, don't have any doubt that the level of this presentation is quite high, and the level of the questions which are being discussed from the global point of view, the scope is quite impressive, breathtaking. So at one session we discussed the correlation between threats faced by a legal framework and those methods they are using in order to minimize these threats. Now we have here even a more global issue. I wouldn't like to pretend that I'm going to make some conclusions to be made by this round table. It's not our task. We shouldn't set this as an objective or to have some perfect solutions. The fact that we are going to determine the limits in the framework of which we are going to discuss these issues this year and maybe next year, that's the right thing. At least we taken some risks to raise these issues, trying to explore these issues. At some point in time it was quite relevant issue for the human beings just to perceive, realize the roots of the law, deception of the law by the individuals and the groups of individuals. But taking into account the entire complexity and intensified way of development of the civil, humanitarian spheres, And the positive law is expanding, and it's a rare occasion when we start discussing the roots of this law, or sometimes we're discussing it in a sporadic manner, just responding or reacting to the specific threats which emerge from time to time from the correlation of GDP growth and reduction of GDP legislated, starting to adjust some regulators in order to minimize the risks they are confronted with, or maybe stimulate some positive trends. But I believe the organizers of this roundtable raised the right questions. So the attempt to determine the definition of law, its roots, fundamental principles, definition of justice, and some original and motivation or incentive principles. I believe all these are the right questions to discuss. Regarding the motivation in law enforcement activities, I would like to come back to this issue, once again repeating that I'm not pretending to provide some fundamental or universal solution. I believe humanity has changed drastically over last centuries, and now it's facing or dealing with different types of problems as it was before. It's submerging into the variety of issues. The way of living of the modern society is quite diversified, and if an individual is not a representative of a highly developing or intensive group of society, still he needs to have proper responses, quick responses, in order to ensure its motivation to the changing rules of life, which are changing constantly. Some peasant from the temple of obelisk faced before. Still, some fundamental principles remain the same. They are driven by the instinct of self-preservation, and even there are two vectors: the desire for goods and the fear of punishment. These are two vectors which remain the same. So we need to understand better how, in this diversity of situation, these two vectors would be implemented. The previous sessions I used to present maybe not revolutionary vision, but my vision to the level of motivation, starting from the first one, empirical one, where the human being is driven by the fear of punishment for the violation of the written laws, and B, the fear of the unlimited law or contradictory behavior of other groups of individuals or individual which can infringe upon the rights and security of this very individual, which assess for himself whether to follow this law or not. So this fear, I believe, has always been the primary motivator to establish the first level of motivation. The second level, a human being, simply speaking, starts using his brain. This is the rational, perceptive, reflective way of behavior, and he's trying to take toll of the previous experience. So he starts understanding that he should not only use these opportunities when the police force would come or the thieves or whatever, but when thousands of micro situations appeared before him around this individual who needs to ask the question regarding the motivation of application of the law, then it results in the conclusion that it would be quite beneficial to live by the law. Maybe not today, but in the near future it would find its way maybe in 10, 15 years. Just a simple example from civil law regarding the breach of transaction, regarding the legislation of many countries, including the Russian legislation. The minor transaction can lead to the non-closure of this transaction. Is it so or not? The fact many transactions are concluded and they can result in many implications from a property asset side, and then it turns out that the implications of this transfer regarding the legal circumstances of this transaction, when the number of these transactions with a certain number of threshold start to be overwhelming, then we face some global problems regarding the trade volumes and rule of law. That was the case with the modern Russian history. And the third level of motivation of application of law, this is the level, a sort of irrational one. And regardless of the fact whether I'll be punished or not for the violation of the law, regardless of the fact to what extent I'm rational in intellectually interested in prevalence of rule of law, then I follow some moral prerogatives, regardless of the fact whether I'm surrounded by those who try to compel me to do so. This is the definition of duty or obligations. I follow some constructions, whether it's based on some moral principles or written laws or some other things, some other assessment, but still I continue to, without any reservations, alternatives, trying to follow what I need to do. Of course, the optimal situation when all these three layers coincide, but still we need to respect or at least take into account all these three levels, at least two levels, depending on their relevance. Just a brief example maybe I venture to make before we break for coffee or tea. When I start come back to routine, I'm suffering a lot from the activities of the owners of the motorboats. Every place where I appear to row, so there are a lot of motorboat owners who do not follow ways of navigations. So I believe this is quite characteristic for Russia. Then I just went to Australia, and it turns out that there are a lot of there's a similar situation there as well. So then I realized that this is a specific category of people, of owners of the motorboats, who live everywhere, not only in Russia. This is the first instance I realized. Then just waving on in my boat, I realized that it's not only that these people present everywhere, they're just willing to be everywhere. And the worst thing is that they don't need to have modern bronze. This is the way of thinking or perception of the world order. I follow speed limits only when I see the policeman standing by this traffic sign. If I see that there is no police force around this sign and I violate it once or twice, then I can continue violating the speed limits without any fear to be punished. And secondly, any suffering from this, I have a motorboat, or a plane, or yachts, or business, or power in my hands, money, and I'm free to use them the way I want it, regardless of the positive or negative effect on the surrounding society. This is quite a demonstrative example. So 2000 years of Christianity, or tradition of Christianity, taught us anything. We still continue to use this paradigm. And I believe another important element, which is promoted by Mr. Sladkov, this is the distinction between law and written law. There are some underwater stones here, and we need to pass between still and Charybd. Otherwise, we are risking just to get down to the dualistic perception of the law. There is idealistic piece of law which is quite far from us, but still in existence, and we have to use it. And we have a written law, which is poorly perceived, often violated, and we need to make a choice between all these two definitions. On the other hand, we shouldn't follow, from my point of view, the normalistic way of perception of the fundamental principles of law, like the theory of law, because in the Soviet theory, law was defined, which is enshrined in the law as the main dogma, and the ruling class. I believe this is the erroneous way of thinking. If you don't have it in the law as a principle, then it's not a principle at all. Then it could be a plague if it's not considered as a principle of law. So we need to take a quite careful look at this regarding the definition of fundamental principles of law, which in my opinion is the definition of law, regardless of the fact that we just walking around these principles for many years, for even centuries. Sometimes we were quite shy to acknowledge this, or sometimes we're trying to use it as the primacy element without realizing the nature of this principle. Now we have two ways in order to overcome this rejection of natural rejection of law. Not only in the Russian society, but in other legal systems of other countries, like what was observed in Tottenham or in New Orleans after the flood, which demonstrates that even in such respected bastions of legal practice and law enforcement, then the first level, the motivation is coming to play. And sometimes police force or military force is not able to reach those places suffered by these floods. They just surround these places without preventing the looting of these places. It's not the sufficient motivation. And the first thing we need to do is, in order to overcome this rejection, no matter how banal it would sound is just to improve the legal framework and way we are applying these laws. You shouldn't use a ton of salt in order to get the salted a ton of salted meat. Maybe you need to use less, but you need to use those specific examples demonstrated by highly professional lawyers, which demonstrate the will of the people to follow the legislation. And we need to reconsider the basic definition of the law. I believe there is a huge, deep conflict and very important correlations of those things which was discussed at the end of the other round table. I mean, those global things which is the control and trust or confidence. These conflicting things, these two conflicting platforms existing in different legal frameworks or systems. There are no systems without control or trust. Of course, we can find for examples, but still this is a sort of balance or correlations of these two notions, which are correlated or adjusted by specific legal systems, taking into account the specific way of thinking of the society and the countries and the way of development. You see, I'm just switching off my mic by myself. A lot of recourses to the Bible history. So the way of rejection of using judges in the Israeli history was the shift or transfer from the system of control to the system of trust, when people selected the judges and when they interfere just on rare occasions into the court proceedings in order to ensure the defense interests and protection, to the system which was ruled by the Tsar, who gradually started implementing the instruments of control, no matter how they call them, whether it's democracy, monarchy, autocracy. But the system, the question is, what is the correlation between the control and trust? This is quite an important element which needs further discussion, especially in the light of the justice and ethnic aspects of law. Thank you for your attention.
Большое спасибо, Александр.
Thank you.
Точно и правильно, наверное, задали рамки направления нашей дальнейшей дискуссии. И спасибо за предостережение.
And thank you so much for your warning against the extremities of realism or positivism. Regarding the coffee break, let us try to fit it within 15 minutes. If you come back earlier, we'll welcome that. So 10 to 15 minutes.
Итак, мы возвращаемся.
So, well, we are back to our section. We have several comments coming up, a bit more detailed as opposed to what we had in the before the coffee break part. I think we should limit each of the comments at 5 minutes, otherwise we'll be way out of our agenda. So we have about half an hour for the discussion. So let us start in the following way. Alexei Pavlovich Kozyrev, Deputy Dean of the Philosophy Department of the Moscow State University, please. The floor is yours. Use the microphone. Distinguished colleagues, dear friends, I am not here as a legal professional. I'm not a lawyer. I'm a historian of philosophy, so it was very interesting for me to hear opinions of very well-known scholars in this area, but still I gather the impression of a bit of a loss. And Dante said, having made it halfway through my earthly life, I found myself in the deep forest. What is going on now in the globalized world, where the civil society issues and minority rights issues provokes this kind of feeling, not only with philosophers, but the lawyers as well. And Professor Van Hook namely mentioned how society influences the decision of the International Court, such as that of the Court of Strasbourg, when they subsequently reverse their previous decisions about the crucifixes. So there's the question whether civil society today can rebel against the decision of a domestic court, as was the case with unprecedented pressure onto the legal system of Russia in the Pussy Riot case. Not only domestic Russian civil rights activists and their foreign counterparts were appealing to courts, trying to reverse their decision. And this provokes the question, because traditionally law was considered a tool of the state. Perhaps something is happening now which makes it a tool of civil society to a greater degree than that of the state, and then how, on what kind of parity considerations these relations should be balanced. This is just a problem which I would like to basically underline, or it can be posed as a question to Professor Van Hook. And then responding to Valentina Viktorovna's presentation representing the Russian tradition of the philosophy of law. And this is great, because this is exactly the feature of this country, that we used to have an outstanding school of philosophy and law represented by the chair of the philosophy of law of Moscow University, such names as Checherin, Novgorodtseva, Vladimir Solovyov, Evgeny Trubetskov, and we used to have the St. Petersburg school, Lev Petrozhitsky, the psychology theory. Unfortunately, after the coup d'etat of 1917, both the schools were destroyed, and then the law was considered as a tool of those in power. And now we are seeing attempts to resume such schools and traditions, and in our university in 2008 we re-established the chair of the history of politics and of philosophy and law. And there are scholars involved in that research, and I believe that we do underestimate today the outstanding traditions in this area which we had before the 1917 unfortunate events. Valentina Viktorovna basically put the law and moral norms, ideal norms and religious norms together. I don't believe that this is exactly to the point, because Russian philosophy of the law was focusing on specifically the Western, the tradition, the rational tradition of the law, from Leibniz to Hegel and Kant, and such representatives of this school as Krause and basically Vladimir Solovyov, when he defines the law as the minimum of the good, apparently looks or leans toward that tradition, which was not part of the Russian Orthodox tradition, but was focusing on the tradition of Krause and Helink in the Western philosophy. And it is interesting that this idea of Solovyov's, which connects morale and law, is put into the basic social concept of the Russian Orthodox Church, which says that the point of the law is not to make heaven heaven on earth, but not to make hell on earth until a certain time, as Solovyov specifies. And I would rather believe that, to a certain sense, this tradition of the Russian philosophy of law went beyond its Western predecessor, because it posed a question as to what is the specificity of law versus religion and beliefs, because we're facing the need to see what makes a legal norm a legal norm. And this is a very relevant issue for Trubetskoy and other scholars, and those appealing to the notion of apparent nature of essences, and looking at, for instance, the norm of the value of a human life, based on which we will be coming up with all other legal norms. And there is also the psychological theory of law, which was also put to work here, and which stipulates that this is the paramount norm as to how to achieve consensus in society and the common recognition. It's clear for the medieval society or the religion-dominated society, when the church is the totality of beliefs, but it is absolutely unclear as to how to achieve that in today's modern democratic society. And I'd say that those Russian philosophers who were at the same time practitioners, the Trubetskoy brothers, were at the roots of Russian political tradition in 1905, provided many answers to those questions, not mixing religion, morale, and the law, but trying to probe for the borders of such definitions. And if we try to answer those questions now, I would like to give you an example of the case in a very highly reputable institute. There was the proceedings in the framework of the protection of the dissertation on the philosophy of Solovyov's, and the learned counsel said, what is the relation on the law on pensions to the good? The law is a formal norm. It has no bearing neither for the good nor for the morale. This is the prevalent positivistic mode, which is inherent for many representatives of today humanities exploring this issue. And this is indicative. And if we do not try to kind of break this perception and say that any law which is being heard, which is being read by the State Duma, should have a bearing for the good, because if it doesn't, it would apparently have for the evil. And that is exactly the notion which is not just linked to religious life or to a specific confession. It has a point for the human being per se. Thank you. Thank you, Alexey Pavlovich. Since Professor Kozyrev invoked the remarks of the two previous speakers, Professor Van Hook, Valentina Viktorovna, perhaps you would like to respond. Since we have only 20 minutes left, try to be very brief. I see that professor is silent. Well, just briefly, I was kind of simplifying it when I said that the Russian philosophy of law put an equal sign between the law and morale, and yet its input into the global philosophical thought is exactly connected with that. The drawback of such approach is exemplified in the discussion between Solovyov and Chicherin. If you read that carefully, you would see that Solovyov was right, saying that the law is a certain minimum within the unlimited moral sphere. It dilutes the notion of law, but as Chicherin put it, and Solovyov was not very happy with that comment, basically it leaves for the state to decide as to what is public morale. But that doesn't mean to underestimate the Russian philosophy of law, because that line of it had a great impact for the Western part of it. And this re-establishing trend makes an emphasis on the moral enhancement of society, but it takes a lot of time. The emphasis should be made on the formation of legal and democratic institutes. Professor?
Well, I agree with what you said, namely that courts have become instruments for civil society, but that's actually a normal result of the rule of law. The idea of the rule of law is that everybody is subject to the law, including public authorities, and it means that citizens can force public authorities to follow the law. And then, indeed, we live in different culture where people know more about the law, where people have more willingness to go to court than in the past, and then it's a normal result. I think it's nothing more to be said about it.
Спасибо.
Thank you. Protoiere Vladislav Tsipin, the professor of the Moscow Spiritual Academy. Distinguished colleagues, I was hoping to speak here, but unfortunately we don't have the time. And since there is the discussion, I would like to be part of it and to continue or to follow up on what my colleagues said here. I'd like to take you back to some of the ideas which Valentina Viktorovna voiced here. I would believe that she very heavily overestimated the irrational component in the tradition of the Russian philosophy of law, which distorts the actual situation. None of those responsible and sound Russian philosophers who wrote about those topics never tried to put the sign of equality between law and morale, law and Christian ethics. Another point is that they insisted on the significance of the moral component in the law, and secondly, on the fact that life of society is not dominated by legal regulation, and the area of morale is more diversified and is a more sensitive matter as opposed to law. And this is true not only for the history of Russian religious development, but also to the genesis of the Russian law per se. Irrespective of the time in the history, it was never an alternative to the Western or European law, because the roots of both are the same. Russian law naturally borrowed its components from Byzantium. In terms of the Byzantine law, we cannot even say that it borrowed something from the Roman law. It was the direct continuation and evolution of the Roman law, which step by step was modified under the influence of Christian ethics. And yet, it was a very accurate, very flexible modification. The point is that it is just apparent, and this was admitted by legal makers in the Byzantium time, Justinian, and before Justinian, Saint Constantine and great Theodosius and their legal consultants who worked with them. They all understood that the ethics of the gospel and the ethics its most important parts can only be implemented in interpersonal relations. It cannot, to the full extent, be applicable to the construction of the state and the structure of the state, and be in itself the foundation of a legal system. Therefore, the Roman law was still there. It was not a consequence of some kind of negligence. It was the consequence of an absolute need. And further on, Russian law was developing under direct influence of the law of Byzantium. Moreover, other sources of Russian law, which, let me put it this way, more authentic, more autochtonic, they were not more important than the Byzantium influences. The Slavic law, if we look at it in more details, it would seem that not very much different from the German law. Russian truth, Ruskaya Pravda, compares quite well with its analogues in the German legal tradition. More or less, it is the same in essence. This is as far as the sources are concerned. And yet, in every national legal system, there are its own peculiarities. You can't do away with, you can't go without it.
These are real facts that cannot be ignored, which should be taken into account. And this relation, what I wanted to say, maybe for the Russian law, Ruskaya Pravo, or starting from the 15th century, maybe not just the times of the Tsar Peter, or this is the supremacy of the law against the narrow definition of law, which is my law. Yes, indeed, this is the specific feature of the Russian law, but it's not of universal nature. Of course, rights which belong to the individuals, they remain to be in place, but the availability of rights to the Russian citizens, they were motivated by the need to serve, to some extent, to the interest of the states or the social well-being, like the right of the landlords regarding the land and the process of the work of the peasants. Say that the peasants were the major force of the Russian military force. Mr. Kluchevsky, historian Kluchevsky, said that the revocation of the krepos or slavery in Russia was adopted 100 years as it should be, so he believed that this should be abolished at the same time as the manifest of the abolition of the military service for the landlords was abolished. So this is the real application of Russian law, and these observations made us make quite cautious conclusions regarding the quite extensive area of the law, because I believe that the Russian and European law is rooted in the same soil. This is the Roman law. This is which serves an important role. Now we are living in the post-Christian or but we have been living in the Christian times. Thank you very much, Father Vladislav, High School of Economics, Moscow. Thank you very much, dear colleagues. I believe this discussion is very important, interesting, and quite useful. Recently, we have conducted the psychological survey of the Russian Academy of Science with respect to the preparedness for the modernization. More than 2,000 respondents were asked, and the first question was the question of justice. More than 40% considered the justice as the priority for the society, then equality, and the last place was devoted to the democracy. That is why the definition of justice and relation between justice and law is very interesting. And of course, justice can be defined differently, and I doubt that we can reach some common ground in terms of definition of this term, because each time we talk about the justice as a measure of equality, then we immediately need to answer what is the equality and who can judge the level of equality. That is why it is very important to ensure the procedure, the process of calculating or determining the definition of justice and how it can be attained or promoted. Even if we have the idealistic definition of justice, and even if we try to apply this in our legislation, the major question would be the implementation. That is why I believe the communication theory provides a lot of interesting solutions, since in the law communication is needed, highly needed, which allows to attain a common ground in understanding whether this norm, legal norm, is fair or not, and we understand that the justice is also amended in the course of time regarding the definition and development of the society, and in this case we can guarantee the legitimacy of this definition, and we can attain the higher justice or fairness of this law. That is why the communication shows some ways how to attain the balance between law and justice, and of course we have some problems here which need to be addressed. They are multifaceted, multi-layered, polycentral, and communication approach probably doesn't take into account the definition of hierarchy, because law cannot be envisioned without hierarchy issues, because court can challenge this issue. Can you sum up? That is why communication around law is very different. Our communication around the law is different to the level they have in the State Duma or in the Parliament and in the government or in the Constitutional Court. In order to warrant the legitimacy of this justice, it is very important to ensure the communication, and we need to try to engage those people which are drafting this legislation. The more extensive the discussion, the better or the closer we are approaching to the consensus with respect to the relationship between the law and justice. Mr. Sladkov, Town of Sarov. I tried to sum up some conclusions, maybe not complete ones. Mr. Van Hook told about some history, Italian history. I would like also to tell you what happened in island of Solovki, where we had the Christian monastery, and after that the prisoners camp. At one of the conference, the crucifixion in the cemetery can infringe upon the rights of Muslims or other people buried there. If she asked if it's the infringement upon the rights of the Christians, she said no. And it was quite sincere answer. What kind of conclusions can we draw from that? Two at least. To what extent, to what universal are our vision regarding the justice and the law? And the second, what are we going to protect using this legal instrument? What kind of way of living are we going to protect? Of course, there could be different ways. Mr. Perevalov says the multiplicity of the humanity. So we need to see this multiplicity and recognize it in our legal framework. Valentina Viktorovna, I can hardly agree with you that the justice is the result of the agreement, and the agreement can be result of negotiations between the equal. I know the history and the perception of justice or injustice. They are in coexistence between terrible things and some good things. And sometimes justice was built on some unfair things. And to some extent it was fair from the point of view of some groups of people and from the point of view of other people. Of course, I understand very well when Minister urges us to be quite cautious in terms of trying to divide the definition of justice and written law. Just try to avoid the mixing all these two things. But the obligation is one thing, but the real things is the other thing. I have a wonderful example, Lev Huxley, which is Wonderful New World. He was written Wonderful New World, and there is a Ministry of Truth and Ministry of Justice, which he described in his novel. From my point of view, the difference between these two or three or even four realities, truth, justice, law, and a legal framework. We have in Russian different notions, so discrepancies serve as description services. We have some trends to develop this justice as it is, but our strive to have this justice. And frankly speaking, I'm a big pessimist looking at what we have now. I remember quite correctly what is written in the Apocalypse, and they using the legal definition. Why we have the end of the world? From the point of view of the authors of the Apocalypse, because in the lack of the law or lawfulness, the love would get cold. This is, of course, I understand this is the Russian translation, and we need to look very carefully how it is written in Greek. Alexander Vladimirovich Konovalov said that an individual has changed just externally. I remember the opinion of a philosopher, Sergei Sergeyevich Karuzhий. He says, what is the lesson of the 20th century? He says the man has shifted and expanded the limits of the humanity. The simple things like Holocaust, of Jewish Holocaust, Russian Holocaust, Cambodian Holocaust, or the sexual changes, sexual market, they are changing our definition of the human being, how it should be determined in a legal framework. Where can we find the changes of the legal perception regarding what we need to do and what should be done? So the common task, general task, is just the resurrection against the collapse of the law. This is our will in order to keep being persons which, from my point of view, are created to the creation of the God. Thank you very much. We don't have time. Mr. Yusuf, Professor Yusuf, Rostov-on-Don, Russian Academy of the Economic Science and Civil Society. Please be brief. Good afternoon, dear colleagues. Very interesting discussion. I believe this is very useful because different viewpoints are presented and we're trying to perceive this. This is what our politicians lack, not only in Russia but in other countries which govern the world or govern the bigger economies. I would like to draw your attention to the fact that we are debating about the future of the world where we're trying to combine justice and law, when at the same time we see two trends which cannot be ignored and which, in my opinion, are related to the topic of our discussion. First of all, this is the unsatisfactory of a majority of the societies in the states with the current structure and the rule of law. Of course, this is the post-crisis phenomenon, but still this phenomenon is growing. A lot of optimism was expressed regarding the United Europe. Recently, RBK newspaper published the survey results of the European member states. 58% of respondents complained that their states are the member states of the European Union. They have pity of that. So no expectations regarding the bright future of the European Union or United Europe. And the second trend is that the communication itself influences somehow the law and justice. It changes all the time regarding the segmentation and variety. Each time we are discussing these issues subjectively, we should take into account that these definitions are formed on Twitter and Facebook websites. If not, so where? If so or not, how can we discuss the combination of these two important definitions? They are extremely important for the world order, today's world order, which we are trying to influence somehow, at least positively. If we're trying to compare these highly developing, highly changing definitions, this is a very serious problem as well. Partially, we touched upon the issue of the law perception and law culture, which are quite important for the future of the world. just few things are done to change the situation, especially by the lawyers. These concepts were among the subtopics for our round table. Everyone talked about this just briefly, and I believe that all those involved in this process, politicians, civil society, should discuss in order to improve the way of living, not from an economical point of view, but from the social and political point of view, and maybe from the point of view of legal perception. I would like to wish all the better living, and thanks to the organizers of this seminar. We don't have time. Mr. Shmylov, the prorector of the Orthodox Svetotykhnei Legal University, Moscow. Just briefly, I'm afraid from repeating what has been said. Of course, I would like to dwell on the philosophical points of view. Much has been said. Maybe I should debate, maybe to agree with something. Just a brief remark which needs to be said, which is very useful for the future deliberations on this topic. This is a linguistic remark. Dmitry Vladimirovich, while speaking, he said that it's not by chance that there are different words in different languages. For different linguistic pictures of the world, it's better understand that these pictures are different. In Russia, the Ministry of Justice could seem something from utopia. Then the Ministry of Justice is the main name of the Ministry of Justice in French, English, no difference at all. So, while discussing this issue, I believe it is very important to formulate the system of translation, especially when we talked about the absolute basics or fundamentals of the Christian or justice definitions. So we called the same things differently. So in Russia it is called fairness, justice. Russia, fairness and justice and law in French and English in foreign languages. Thank you very much. I would like to apologize to those who didn't say something or presented their views. Discussion is still open. We still need to continue this, and there is a need to continue these discussions, and we will continue to discuss this issue in the future. I would like to frankly to thank all of you who participated in this discussion. Thank you very much, and let's continue thinking about this topic, and I do hope that it could lead us to some wider discussion of this issue. Thank you very much. All the best.